Hi, everyone. Harry here to talk about this morning's flurry of 4 Supreme Court opinions and what's ahead. What's ahead is the bigger headline because they have nearly 20 cases left to announce, and we are really close to the end of the term, which is traditionally the end of June, possibly bleeding into July. So we still got a heap of cases, and I'll talk a little bit about them at the end, what we're waiting on. But we can probably expect multiple decision issuing days next week. Okay, but we had 4 today. None of them any of the sort of headline cases we were looking for or barn burners. Some have interesting lineups. Some are interesting inherently, but again, as we sort of held our breath as each of the 4 was announced, and none of them was the very high profile cases. All right, so let me just go through them quickly. So, the first case was Moore versus United States. And that concerned a so-called repatriation tax. Basically, if you own stock in a foreign corporation, Congress has said you have to pay a one-time tax. And is that constitutional under the Congress's taxation power? It's basically a protectionist and revenue-raising law. The court upholds it 7-2. And Justice Kavanaugh writes it. Justice Thomas dissents, joined by Gorsuch. And there's a concurring opinion, Barrett by Alito. So there are 5 solid votes for it, but there's a concurrence, Barrett joined by Alito. And Thomas, joined by Gorsuch, is a sort of basic Thomas announcement of a idiosyncratic constitutional provision, which he seems to do with some frequency and often hoping to lay the groundwork for the court eventually to go his way. But what he said is 16th Amendment income, that's where you get the power to do income tax, has to be income realized by the taxpayer. So tax on earnings from a foreign corporation or just on stock for a foreign corporation is unconstitutional, and Gorsuch is with him. But 7-2, and the Barrett joined by Alito, other concurrence, and that's the news on that one. The next one, Ciavarini, Justice Kagan writes for 6. And it has to do with 28 U.S.C. 1983, a very important statute that lets people sue for constitutional violations civilly. And that includes suing a officer of the U.S. or of a state for malicious prosecution if they arrest you without probable cause. And they have to know it, and there's a whole immunity issue. But what happens if they arrest you without probable cause on one charge, but then they arrest you on other charges and there is probable cause? Can you sue them for just the one? And 6 members of the court say, yes, you can. At least theoretically you can. So this is an interesting point that I think Kagan is thoughtful and even cunning in inserting based on what we are going to see in the immunity opinion. Because what she says is we're just deciding today that it's not a categorical bar that you're arrested for something else and there is probable cause. If you're arrested for something without probable cause, you can still bring the malicious prosecution claim. What's the test exactly, and when can you, and when would a arrest with probable cause overcome it? We're not going to say. We'll leave that for another day. For now, we'll just say it's not a categorical bar. And if there's a test, we can elucidate it later. So you can see the anticipatory echoes, if you see what I mean, with the immunity case coming up, where the court is already has in its question presented, but is taking on itself all kinds of questions and legal issues, or so it appears, that are unnecessary to the really important legal proposition that the court needs to settle, which is Donald Trump can be sued. He doesn't have criminal immunity for the charges Jack Smith has brought, but there's some indication from especially the questions at oral argument, especially from Justice Alito, they're going to go far afield. So that's a little marker that Kagan has laid down in the Ciavarini case, which was the second of the day. Then the third case is Diaz. An interesting little case if you're into evidence, as I am, but basically you're not allowed for an expert to say, here is my expert opinion of this defendant's state of mind. What you can't, that's not a proper expert opinion. You can give expert opinions about how people act in general and the like, but you're not a shrink unless you've actually examined the defendant. So we have someone who's bringing drugs across the border, and she says it's her boyfriend's drugs and she has no idea. And they wanted to have an expert testify that that's crazy. People generally, I am, a drug agent, and I can tell you that's not what people do. They don't let that much drugs be taken over by other people. This is one of these trucks just stuffed, or vehicles completely stuffed to the rafters with drugs. And so the Supreme Court in Diaz says it's okay for the expert to testify about most defendants. What they can't do is give an opinion about this defendant. So it's upheld, but you have to be careful that it's about most defendants and not specifically about the defendant there. What you're going to hear in this case is the lineup is unusual. Thomas writes the majority for the court. Jackson joins him, and she also has a concurring opinion. And then Gorsuch writes a dissenting for three of the court, including Kagan and Sotomayor. This is the sort of thing you get at the end of every term. Oh, look at this strange lineup in this case. It shows that the characterization of the court is monolithic and conservative is just unsophisticated and inaccurate, and the court is now moving in different ways, etc. Short point here, don't believe it. This court and all Supreme Courts are known by the big cases they do. When we have a case like Dobbs, where you see this kind of lineup, then you can say this. But the fact that in some particular evidence case, you have this unusual lineup, really, I think tells you nothing about the court or some supposed erosion of the conservative muscle flexing that we are completely in the middle of still. And then finally, the Gonzalez case. Remember, recently there was in the mifepristone case, the court ruled unanimously no standing and slapped down the Fifth Circuit. The Fifth Circuit has shown itself to be really a rogue conservative court, very activist, even for this court. And this is another slapdown of the Fifth Circuit. It's done per curiam, which really shows the court is, basically firm and saying we mean it. This is a case in which there was allegedly a retaliatory arrest, and the court said there is a narrow exception that this case might, in fact, apply to, and remanded to the Fifth Circuit to apply what they said. And the Fifth Circuit just didn't do it. It changed the law as it seems want to do. So the per curiam is a way of saying, we weren't kidding, go do it right. And it's a real sort of slap on the wrist to the Fifth Circuit. Nevertheless, here there are separate opinions, and Thomas actually dissents. So there are different concurrences, 2 or 3, and Thomas dissents. So in the same way, a kind of unusual or idiosyncratic breakdown of the court overall, which people will point to. But again, it happens especially at the end of the term when you have the most challenging and high profile cases. They take the longest, and they're most likely to produce different strange bedfellows and different concurring and dissenting opinions. Okay, so that's today. That's 4. Four's a lot. If there had been even more, I think it would have been an indication that the Chief Justice is really, really pushing on the court to get things out. As I say, there's still almost 20 to go, including all the high-profile ones. I think that translates to several opinion issuing days next week. The court is in its final, they're around the bend and going into their final sprint to the end of June, early July finish. That means we still have to hear the immunity case, of course, the Fisher case, which is about obstruction, a charge brought against Donald Trump in the federal cases against him, and that could really narrow his exposure. The Idaho case, Moyle, where the question is whether Idaho's law conflicts with federal requirements. This is an abortion case for emergency treatment. The Idaho statute defining or preventing, outlawing abortion except in very narrow circumstances, that the United States says it is inconsistent with federal law and how federal doctors are instructed. The Raheny gun case is there a constitutional right for somebody with a domestic violence conviction to be prevented from carrying a gun? And with that might come a whole argument and intramural dispute about how you analyze these things, and the court's zeal for a history and tradition test that they've done in other Second Amendment cases. Will that hold, and will the majority endorse it? And then finally, the case involving an effort to deal with homeless persons. That's a kind of ratchet up from a fine, but eventually has the possibility of imprisoning people for being homeless, which the court before has indicated that's a so-called status crime, not a conduct crime. And the Constitution, the argument is that the Constitution forbids it. We'll see what the court says here. Okay, so 4 cases, some a little bit interesting, but not as interesting as people will make them out to be. And the big ones still to come, and going to be quite a flurry and rock'em sock'em week next week for sure. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.